Hello, my name is Robert Miller. I'm a principal at the law firm of Manier & Harrod in Nashville, Tennessee. My practice focuses on the area of bankruptcy law, in particular representing sureties in bankruptcy proceedings. Today I will be discussing Chapter 15 proceedings, which are commonly termed as international bankruptcy proceedings. First, I'll be discussing the origins of international bankruptcy. After that, discussing the framework for how international bankruptcy operates. Then, discussing protocols which govern procedures as well as coordination among courts. And then lastly, I'll be covering the model laws that govern international bankruptcy in many jurisdictions, including the United States, under the Chapter 15 enactment. The origins of international bankruptcy are based on comity. Comity is the giving of effect of the laws of another nation. It's not an absolute obligation, but it's more than a courtesy. Why is comity necessary? Because there's no overarching framework to enforce international law, much less international bankruptcy law. Unlike the Constitution in the United States, which has both the Bankruptcy Clause and the Supremacy Clause to ensure that states must follow federal law, there's no analog in international bankruptcy. Comity works under the principle of repeated gains. If one court recognizes another court and gives the effect of that court's laws in its jurisdiction, the recognizing court can be confident that its action will be reciprocated by the other court. Over time, a virtuous cycle occurs, and there's more confidence that there will be recognition and comity between those two courts. If this applies between and among many nations, it can create a stronger web of comity that allows for greater recognition of laws amongst those nation states. Sometimes you'll run across the enactment of 304 of the Bankruptcy Code. That's the predecessor to Chapter 15. That enactment was repealed when Chapter 15 was enacted, but that's some nomenclature, and sometimes you'll see cases under Chapter 15 cite Section 304 cases as precedent because some of the ideas that were used and enacted as part of 304 are still in place in Chapter 15 because much of the framework that deals with international and governs international bankruptcy law remains the same. The framework for international bankruptcy is based on recognition. Let's take the hypothetical of an entity that has its principal place of business in the United States, but has parcels of real estate in Canada. Its most significant relationship is to the United States. It files a Chapter 11 proceeding in the United States. The United States would be considered its center of main interest, or comity. The substantive law, United States Bankruptcy Code, would govern the assets within the territorial jurisdiction of the United States. However, the Chapter 11 Bankruptcy Court would need the aid and assistance of the Canadian Bankruptcy Court to govern the assets in Canada. As a result, a representative of the United States debtor would apply for recognition of the United States Chapter 11 case as a main proceeding in Canada. That would be an ancillary proceeding. There would be a determination by the Canadian Bankruptcy Court whether to recognize the United States Chapter 11 proceeding as the main proceeding, as the center of main interest. And then there would be a determination as to what relief would be granted, whether there should be a turnover of assets or whether there should be the requirement that creditors of the ancillary jurisdiction file claims in the main proceeding are some of the more significant substantive issues that can be determined as part of recognition. Protocols are one-off contracts that are created bespoke for bankruptcy cases that govern the coordination and procedure between two international bankruptcy courts. They generally deal with case scheduling, communications between the judges, how hearings are going to be handled, Famously, in the Nortel Networks cases, there were contemporaneous hearings held in the United States and in Canada to deal with the fact that the debtors had significant assets in both jurisdictions. Lastly, let's discuss the model laws. The model law for the United Nations Commission on International Trade Law regarding insolvency is the basis for the enactment of Chapter 15 of the Bankruptcy Code, as well as insolvency laws in many other countries, including the United Kingdom, Canada, Japan, and Mexico. The European Commission regulation on insolvency proceedings is, although not the same as the model law, shares many of the same characteristics and is based on the same framework that we discussed earlier with a recognition of the main proceeding by the ancillary proceeding. One of the advantages of the model law enactments is that it creates a deep body of case law quickly, as the jurisdictions who have enacted the model law are all interpreting substantially the same provisions. As a result, you can use United Kingdom or Canadian precedent or any of the other jurisdictional precedent in a Chapter 15 case for interpreting provisions of Chapter 15. As a result, there are more precedents out there than there might otherwise be, given that Chapter 15 is a relatively new enactment as part of the BAP-CEPA amendments in 2005. For more information, please check out the International Insolvency and Chapter 15 chapter of the surety aspects of bankruptcy law and practice. I appreciate your time today, and if you have any questions or comments, please feel free to reach out to me through the information that I provided on the first slide of this presentation. Have an excellent day.